This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. I'm Catherine Eaton, an accredited collaborative family law attorney and a member of the Florida Academy of Collaborative Professionals, also known as FACP. Today's guest is Susan Keys. She's an accredited collaborative family law attorney also, who practices family law for the past 35 years, I believe, right? Susan is also a Florida Supreme Court certified family mediator and is certified as a parenting coordinator. She restricts her practice to non-adversarial, solution-based methods of resolution, such as collaborative divorce and pre-suit mediation. She's a member of the mediation firm Divorce Without War. She's the immediate past president of her Miami practice group, known as Collaborative Family Law Institute. She currently serves on the FACP board and is a member of IACP, which is the International Academy of Collaborative Professionals. Welcome, Susan. Thank you for being a guest today.
Thank you for having me.
I wanted to talk to you about how you became involved in the collaborative process, learned about it, and decided this is the way you prefer to practice family law. How did that start with you?
Well, like all careers, it's a process. I started out practicing commercial litigation in New York in a big firm. I saw what that looked like. I navigated to a family law firm, a big family law firm in New York that did high-end, high-profile divorce cases and celebrity type cases. And that, even though I really loved the area of practice, that was still serious litigation, very contested and expensive and acrimonious litigation. I moved to Florida. I continued in the same field doing family law litigation and eventually got certified as a mediator because I always liked the part of the case where it got resolved. And I really enjoyed the mediations, which are required in all family law cases before a trial is granted. And I always settled my cases at mediation. And then I started doing some mediation for attorneys. And little by little, I really liked mediation and a collaborative approach to resolving cases. And then I got myself into the collaborative space. And I would say that now 80% of my time I'm representing individuals in the collaborative process, and really 20% of the time focused on pre-suit, pro se mediation. But I think that doing mediation helps change the words that you use, the approach, and it really forces you to see another perspective, to really understand both sides. And I think I bring that into the collaborative process because understanding all the interests of all the parties, all the perspectives helps you to, I think, structure best options and better outcomes for families. So now that's really the only space that I'm in. I do not do any litigation, thankfully.
When parties are in the collaborative process and they each have an attorney, I mean, we refer to it as the team, and we take a team approach to help the parties find a resolution. Would you talk about how parties can be each represented by an attorney, but there can still be a team approach in finding a resolution for the parties?
Yeah, well, I mean, I think teamwork, where everybody brings their best work to the table, offers the best outcome. It's sort of the concept of 4 eyes are better than 2. And anything that you do collaboratively with another individual, you bring your best skill set. So a team approach to me is so ideal in a family context. The attorneys are advocates, understanding the legal and substantive issues and addressing those. The financial is gathering and interpreting information, which sometimes lawyers do, but don't do it as well. And providing schedules and coming up with perspectives on the finances. And then we have a facilitator who's trained in the mental health field, but isn't providing mental health, of course, but helps keep the communication elevated, healthy, and productive, keeps everybody on task, elevates behaviors, and perhaps biases that may be affecting the process and outcomes, and identifies issues that are in the way and roadblocks to settlement. So we have this team approach to everybody doing their best work and bringing their best skill set to a solution-based method. And to me, it's the most ideal approach to resolving a family conflict.
How long have you been practicing collaborative?
Well, I moved here in 1994, and I would say for the first 10 years, I was still doing litigation and mediation. Since I would say probably about 15 years, I've been doing the collaborative work. And of course, progressively more and more and more, because the relationships between collaborative attorneys, collaborative financials, collaborative facilitators, as we form these groups and network with each other, the trust builds and the relationship builds. And then that's really the only world that I'm in now. Those are my colleagues, and we cross refer and do our best work together. So I've been in this space for at least more than a decade, 15 years, I would say.
You mentioned earlier that before you can litigate and go in front of a judge, whether it's, for a full blown out trial or whatever the issue is, that in Florida, you're required to go to mediation. So everybody knows the word mediation. I mean, you say that everyone goes to mediation, and I'm sure everyone listening says, oh yeah, mediation. They know that word, they've heard that, but people don't have the same recognition of collaborative or the collaborative process. And you've been doing it now for 15 plus years. So that's one of the reasons why we're having this podcast, is because we want everybody to know the word collaborative or collaborative process. Why do you think more people and even attorneys don't know about the collaborative process?
Well, I think it's a formal process that people use the word collaborative, but they don't realize it's a formal process that people are trained in. And so they don't know how to seek out the people that are trained in that process. They might go to lawyers and say, I want to do this cooperatively. I want to have a collaborative approach, or use words that sound like that, but not enough attorneys are trained in that field and offer it. That's the first thing. And so we have to help clients who come in cross over from what they're describing they want to really seeking out that formalized process, and also having more attorneys trained in it, and of course judges understanding it. And that's why we're doing this. We're trying to get the word out there. It's a requirement that you offer options to clients that come in and interview you, and to start with that, and offer them options for how to approach a divorce case, because how you get divorced matters. It matters on outcomes. It matters on the healthiness of the relationship post-divorce, and it also impacts children significantly. So I think more people have to understand what that is when they use words like, I want a cooperative approach, or I don't want war. What are the options for them? And attorneys need to offer those options in a more comprehensive way and more clear way, so that clients know they can elect a collaborative process that really is a path that stays outside of the court process and remains outside the court process all the way until the conclusion and a global resolution is reached. It's about communicating properly.
I think that's the most common fact that anyone who knows about collaborative is, oh, we're going to stay out of court. But that's one part of it, but it really is a different procedure and process. So it's the collaborative process. Will you explain how the collaborative process is different than mediation?
Sure. So mediation is a negotiation where you have a neutral, trained professional that either helps the parties without lawyers or helps the parties with lawyers reach a resolution. And a lot of times that neutral professional will go from room to room with the parties and discuss outcomes and try to find a middle ground between them. It's a great, productive, economical, resourceful, terrific style, but it doesn't really let the parties talk to each other or be their own advocates. They still have somebody speaking for them in a way. In a collaborative model, you meet as a team and you are face to face with your spouse, with the person who you're trying to resolve the conflict with. And it promotes communications between those individuals, of course, with guidance, with an agenda, with an organized plan for that communication. And it's really focused on interest based. What is it that this person really wants, and how do we get there? And the meetings are run by the lawyers and the mental health and the neutral, but the clients get to speak to one another and they really communicate. So it really promotes more cooperation between the people that are resolving the conflict than a mediation style cases. Both of them are designed to reach a resolution and not have a judge decide. That's the ultimate goal of both of these processes. To not have a judge decide the outcome for these parties, because judges can't customize and can't drill down on what they really want. That's a more formulaic approach. There's not enough time in the court system to really resolve a conflict between two people by really understanding all the parts of the conflict and letting them decide. The judge will decide. So mediation is similar to collaboration in the sense that it builds communication. It's not decided by a judge, but the process of getting there is very different in mediation and collaboration, and also the communication between the individuals is promoted in the collaborative style.
I think people watch movies and TV shows and they think they know what happens in court and what happens in family court, and that all you have to do is get up and tell your story, and then the judge will figure it all out. But that's not really what happens in court, as we know. It's not about telling your story, and it's not that the judge just comes up with some creative solution for each story told. So would you speak a little bit about what judges do or what they're restricted versus in the collaborative process, how the options really are endless? Can you speak about that difference?
Yes. I mean, a judge is constrained by following the law. Absolutely 100%. Otherwise, I guess it could be appealed. And also the judge is not really designed to listen and understand and say, well, how's about we do this, or how's about we do that? They're not being as resourceful and customizing they can't, they don't have the time to do it. They have a long docket. They have to get people in there and out of there. And also in a judge trial, sometimes you have one day with the judge and then you don't see that judge for the remaining part of your trial for 3 more weeks. And in between, there's been all kinds of other matters. So how can they possibly remember all those details? So judges are constrained by the law. They can't build on options. A silly example that I sometimes use is the example of the lemon. A judge says 2 people are fighting over a lemon. He either decides to give the lemon to the husband or the wife and compensate the other person, or he cuts the lemon in half. Those are the only solutions that are typical for somebody that's not really taking the time to listen to these parties and why they're struggling over this lemon. If you talk to the parties, if you drill down and you really understand, why do you want this lemon so much? Talk to me, wife, or talk to me, husband. You might find out that one has a lemonade stand and one is a baker, and one uses the zest and one uses the juice. And by talking to them and taking the time and really drilling down, you come to realize another way we can solve this way. How about somebody takes the rind and somebody takes the juice. And you're both now happy with your outcome. But I didn't think of that because I'm not trained to come up with those kind of other solutions. I'm a judge and I've got a million cases and I don't have the time to listen to all the whys. And so in a collaborative process, we really come to understand, what is it that's worrying you? What is it that's troubling you? What is it that you really want to achieve? We find that with homes sometimes. I'm willing to sell a home, but I'm really, really worried about my child's first semester of college. I would like to keep it through the first semester and let them have the first winter break at home. Well, maybe that's doable. Maybe we can set up an arrangement where we don't sell it till after that. And so when you start to hear what people want and why, and you try to approach it from that perspective, and it takes a lot of listening, and a lot of letting the other person listening understand the other person's interest, you are better equipped to come up with solutions that meet the needs of this family. That's just not a practical approach in a court context. It's just not possible. And so I just find that we can really, really be more creative, and have more time to listen and understand the issues in a collaborative model versus a court traditional litigation model.
I'm going to switch topics just a little bit. Last summer, the law changed in that now there's a presumption that parenting time time sharing is going to be equal between the parents. Are you finding, because of that change in the law, that that parties are approaching that it's going to be equal, or are they still open and flexible? Do you think that, I mean, in collaborative, we talk about interest-based and options and different ways to do it. Are you finding that those conversations are still taking place, or is it more of, oh, it's going to be equal, so it just gets glossed over? What has the effect of the statute been?
Well, it's hard to say, and there's also been changes in the alimony statute. From my perspective, the more clarity there is in the law and what could happen and what a judge could do in a court setting is making collaborative even more appealing. Because when you see that there are just so many ways and outcomes in a court process, and you have the options to do anything you want in a collaborative process, I think it's made it easier. Collaborative is about working together to create the best transition and the smoothest outcome for the family. So if people recognize that the arrangements are better for the stay-at-home husband to have more time with the children versus the working wife who has to travel, and you're not focused on what would be the time sharing in a court process and really what's best for children, it makes it more appealing to be in collaborative and to do what's best for the family versus what might be the outcome in court. And I think that it's good to have that clarity. If you go to court, this is more or less how it's going to look. And here, you know that it's not, that wouldn't be the best outcome, so to speak. I think it's been helpful. It's also leveled the playing field a little bit on negotiation, where somebody might hold that as a pawn, the time sharing resolution, for better outcomes in the financial aspect. So knowing sort of how this might play out in a court process, I think has been helpful to the creativity that aligns with the collaborative process.
That's a really good point. I like that. I like that thought process. You mentioned alimony change too. So in the same vein, is that changing how people are approaching the alimony when they're in the collaborative process, or how do you think this statute?
I think so, for the same reasons. I think when we have some clarity on sort of the black and whiteness of how things are able to be done in a court process, like you explained or asked me earlier, how would a judge handle that? Well, we don't ever really know. That's the problem. Why let somebody who doesn't know you and we don't know what they're going to think or do resolve your matter? But that kind of clarity kind of gives you a little bit of more of a formula for approaching things in a collaborative case. And by explaining sort of the constraint that you would follow in the legal process, in a court process, versus the latitude and creativity that you have in a collaborative matter. So perhaps in a court matter, the alimony would only be 35% of the difference in the incomes, et cetera, et cetera. And that's a real fundamental issue for the recipient spouse in a collaborative case, that 35% won't it just seems too little. Or well maybe that is a negotiating point, the fact that you can move off of that to a different sort of outcome, maybe in exchange for other things that are important to the payor spouse. So you can use these outcomes that would be more absolute in a court process, and nothing's absolute in a court process, of course, as negotiating points in a collaborative model. And even with the clarity of the law and what we're seeing in the changes in time sharing and alimony and statutes, there's always this risk that a judge is not deciding, within those constraints, and that there's mistakes in a court process or misunderstandings in a court process, or the latitude goes disfavorably to one of the people in the wrong direction all the time because the judge doesn't like them or has a bias. So why ever be in a court process? It's more expensive, it's more acrimonious, it takes the communication away from the parties. It's not as efficient. To me, I don't see any place for a family matter to be solved in a court setting by a stranger.
I agree with you, of course. And you just mentioned it, how expensive litigation is. Can you just explain a little bit that how litigation really is the most expensive route to get a resolution? And as we just discussed, it's the end result is probably not as favorable to either party because so many details can't be considered by the court. They just don't have the ability or the time. So why is it so expensive?
Well, in a litigation model, of course, you have two attorneys that are gathering information and trying to understand the case. That's similar in a collaborative model. But in a litigation model, you don't tend to have one neutral financial professional who's gathering information, streamlining that information and sharing that information with both attorneys. Typically, each attorney has their own neutral financial professional. So right there, you're spending more money. It's not as streamlined. I think that the worry that you're strategizing in a court process, that you're building a case, so to speak, requires more work and more expense in a litigation model. Each attorney is strategizing, taking depositions. They're not relying on information that's given to them. They're seeking the information on their own. The collaborative model with this one neutral financial professional relies on good faith and sharing of information. There's no requirement and even necessity or even option to take depositions or to subpoena records from banks. People are supposed to share that information. And so the gathering of information and the analysis information is more streamlined. Right there, we are saving money and we are cooperating to get information that's necessary to make decisions. And there's no strategy building. Sharing information in litigation creates fear. You need to keep things in your pocket and behind your back so that you can prove things and surprise people. Whereas in a collaborative model, there's a requirement to share information and get to the bottom lines together, understand information together and cooperate on understanding that information. So the savings are very significant versus the litigation model. Also, there's delays in a court process. You think you prepare for a hearing and then there's a problem and the court has an emergency. So you've prepared and you don't actually have the hearing. Clients still get charged for that. Traveling to hearings, preparing for hearings, getting witnesses to come to hearings, all of that costs money. None of that takes place in a collaborative model. We get down to the nitty gritty. What do we need to understand? How do we share information? What do we need for our meeting? And you streamline that information and streamline the communication and streamline the people that are deciding things in such a way that it preserves the family's resources, which is in the first place what a lot of people are fighting about. So why spend resources that you're fighting about by giving them to other people instead of preserving them for your family?
Thank you. That's a great explanation. I appreciate it. And thank you for being our guest today.
Well, just remember that the real victories are those of peace and not war. And I think more people should work together in a collaborative model to try and achieve better outcomes for their families and build post-divorce communication, benefits for their children. And I really am a strong believer. I've made the shift. I know you've made the shift, and hopefully more people will understand the collaborative model and know that it's a better outcome, a better way to approach your divorce. Thank you for having me talk today.
Thank you.